Good afternoon, everyone. I'm Peg Schaefer. I'm the Director of Development and Communications at Midwest Environmental Advocates. Welcome to the webinar. We're going to get started in just a few minutes. We're going to give another minute or two for more folks to come into the webinar here. All right, I see that a majority of the folks that we anticipated to join us will have joined. So we're going to go ahead and get started today. Again, my name is Peg Schaefer. I am the Director of Development and Communications at Midwest Environmental Advocates. And today's webinar will provide an overview of EPA's proposed National Primary Drinking Water Regulation. We're going to talk about the effects of the federal rulemaking on drinking water and groundwater standards here in Wisconsin. We'll talk about issues related to the state budget and more. Today's presentation will be followed by a question and answer session. So if you have questions for our presenters today, go ahead and enter those questions into the Q&A feature, which you can find the button down at the bottom of your screen. If you can avoid using the chat to ask questions of the panelists, that will just make it easier for them to keep those questions kind of organized. And with that, I'd like to go ahead and introduce our two presenters today. Jorge Roman-Romero is an attorney at Midwest Environmental Advocates, and he is a fellow with MEA. He's been with us for almost 2 years. Jorge focuses on PFAS issues in the state. Excuse me, just turning my screen here. He focuses on PFAS issues in the state and advocates for at-risk communities around Wisconsin. Peter Burress is the Government Affairs Manager at Wisconsin Conservation Voters. He works with the legislature, the governor's office, other state agencies and partners to advance conservation priorities in the state budget, the legislature, and in various rulemaking processes in the state. With that, I'm going to go ahead and hand it over to Jorge to get us started.
Thank you, Peg, for the introduction. And so, yeah, I'm gonna provide a very quick roadmap, a quick overview of some of the subjects that I'm going to cover here with Peter. And so first, I'm going to start at pointing the statutory authority of the rulemaking that emanates from the Safe Drinking Water Act, delineate very briefly the scope of the regulation, and then I'm going to move us to the standard development process, and then we'll be discussing some primacy compliance and enforcement issues. Then we'll transition to just discuss how that EPA rulemaking affects or can affect state regulatory matters. And then Peter is going to join the conversation with discussing the Wisconsin PFAS budget and how that is an important part of this conversation. And then, as Peg alluded to, we'll have a questions and a call to action section at the end of the presentation. And so First, to note that this rulemaking stems from the Safe Drinking Water Act. Provision, the section 1412 requires the agency to establish national primary drinking water regulations for contaminants that may pose a public health risk, that are known to occur, or they're likely to occur in public water systems with a frequency and at levels of public health concern, and for which the administrator determines that regulating these substances in public water systems presents a meaningful opportunity for health risk reduction. So EPA is using this authority after making those predicate determinations to regulate 6 PFAS out of about 12,000 or more. And this regulation will apply to drinking water from public water systems, excluding transient systems, which are systems that provide for drinking water in certain locations where people do not remain for long periods of time. So that is sort of the scope of this regulation and how it applies to public water systems. It is important to note that this regulation does not directly apply or seeks to protect people that rely on private wells for drinking water. So that is an important thing to note. So what PFAS are subject to this regulation? I have listed them here: PFOA, PFOS, which are the most studied PFAS of all. Then we'll have PFNA, PFBS, GenX chemicals, and PFHX. I've listed a few of the adverse health effects. I'm not going to really go into detail here because I think we are pretty familiar with the adverse health effects associated with oral exposure to these substances. I just want to briefly note and highlight the relevance of the classification given to PFOA and PFOS by the agency. So this is the first time that EPA classified these two substances as likely to be carcinogenic. And so that will have an impact in the standard development process, as soon we will see. So a quick overview of the NPDWR development process. First, the EPA evaluates some of the data, and that includes occurrence data, in toxicological studies, epidemiological studies, and so they determine whether they have enough data to establish a health-based goal known as the maximum contaminant level goal. So a maximum contaminant level goal is the level at which no known or anticipated adverse effects on the health of person will occur with an adequate margin of safety. So this is what I call the risk assessment portion of the process, where EPA sets a health-based only value. Then EPA is charged with developing some alternatives with the purpose of setting an MCL, which is a standard that is supposed to be set as close as feasible to that health-based goal previously determined. This is what I call the risk management portion of the process, because in here, EPA is charged by the Safe Drinking Water Act to add into the health-based number, to add into that equation some cost and technological considerations. And through that process, it derives a proposed maximum contaminant level. And then EPA has to perform an economic analysis just to justify the regulation as a cost-justified decision-making process. As the overview of the standard development process under the Safe Drinking Water Act, I want to zoom in and focus on two concepts previously explained, just to make sure that we understand the distinction between these two. And so the MCLG, as I said, is a health-based only. It only considers health-based data and is non-enforceable. And so then we have the MCL, which is what would become an enforceable standard that needs to be set at a level as close as feasible, taking into consideration the cost and technological factors. And so we are going to see how these two different values or concepts play with the specificity with the PFAS seek to be regulated in this rulemaking. So first, I'm going to talk a little bit about the MCLGs and MCLs for PFOS and PFOA. So as I alluded, as I mentioned before, the EPA for the first time officially classified PFOS and PFOA as likely to be carcinogenic, and therefore EPA has a long-standing practice of establishing the MCLG at 0. So the health-based goal for these two substances is 0, which indicates that there's no safety level of exposure to these chemicals. Then the MCL, so the risk management portion of the process, where technological factors and cost is considered to come up with this number. And so given the available analytical methods to measure and treat these chemicals, EPA decided to propose an MCL of 4 parts per trillion. And so they also analyzed the cost implicated from a 5 parts per trillion and a 10 parts per trillion, and they say that they determined that 4 parts per trillion is cost justified. So that's how the EPA used technological and cost factors to set an MCL at a level as close as feasible to the MCLG, which is 0 in this case. So here I'm gonna spend a little bit more time explaining the MCLGs and the MCLs for the other 4 PFAS. Just as a preliminary matter, need to note that EPA is proposing to regulate these 4 substances as a mixture. And in order to do that, they are intending to use a hazard index approach because of their known additive toxic effects and the fact that they are likely to co-occur or occur together in drinking water. So the MCLG that the EPA is proposing is a hazard index of 1, which we'll soon know more in detail what that really means. And so whenever any mixture containing 1 or more of them has that particular number, so this is the level that represents a level at which no known or anticipated adverse effects on the health of persons is expected to occur and allowing an adequate margin of safety. So what the EPA is telling us here is that while there may be some doubt that exposure to low levels of one of these substances may not produce adverse health effects, once you consider them as a mixture, then you do have, because of their additive toxic effect function, you do have a public health concern. And so they said that MCLG hazard index of 1. The MCL essentially is the same. EPA determined that it is also feasible to set the MCL for these substances and for any mixture containing 1 or more of these substances as a hazard index of unitless 1, 0. So what does this really mean? Like, what is the hazard index and what is the mechanisms of this tool? So just to set a little bit of the context, this tool is designed to evaluate the health risks from exposure to multiple chemicals of concern that have similar adverse health effects. So this is the dose additive function assumption here that EPA has used. And so how this is calculated, it is essentially calculated by dividing measured levels or detected levels of each PFAS compound by its associated health-based water concentration. And if you plug the numbers and the hazard index shows that is greater than 1, then there is an exceedance of the MCL. Just very quickly to know that health-based water concentration is defined, is proposed to be defined in regulation and is a health-based value. So how does this really work? So here I put an example. Let's say that a public water system has detections of PFAS at 7 parts per trillion, which is below the health-based water concentration, but also detected levels of PFNA at 4 4.5 parts per trillion. And so you try to plug those numbers in using the health-based water concentration. You add those up, those ratios. And if you have, in this case, a 1.15, that is an exceedance according to the proposed MCL using this hazard index approach. I included the health-based water concentrations in that table so that you have an idea of how the mechanisms of this tool. But that is essentially how it works. So now I want to talk a little bit about the rule-making timeline, and that will get us into a discussion about some primacy and compliance and enforcement issues. So as you know, the rule was proposed and published in the Federal Register on March 29 of this year, and that opened up a comment period that will close on May 30 of this year. EPA is expecting to finalize the rule by the end of 2023. We hope that they are able to meet that goal. For purposes of this discussion, we're gonna assume that that's going to happen. And so if they are able to finalize this rule, then the Safe Drinking Water Act has some deadlines of things that need to happen once the proposed rules become final. And so first is that within 2 years, states with primacy status have to submit a revised program incorporating these standards into their state programs so that EPA can approve those updated programs. And that needs to happen within 2 years, which in this case will be the end of 2025. Then we have the effective date. So when are some of the requirements stemming from the regulation will be due, and that is 3 years from the final promulgation of the rule. So that will put us by the end of 2026. Then we have 2 other caveats here that are included in the Safe Drinking Water Act that talk about when agencies with primacy status will ask for additional period so that they can revise their program and submit that program from approval for the EPA. And so if that happens, which we will soon talk about when and how that may happen in Wisconsin, that will put the agencies receiving approval from the EPA for that revised program by the end of 2027. And also, last but not least, the Safe Drinking Water Act sometimes contemplate that for some reasons, utilities may need additional time to comply with the regulation. And so sometimes the EPA has authority and has used it before to add 2 years to that effective date, which that will put us at the end of 2026. Here it is important to know that the proposed rule states that EPA does not intend to provide these nationwide 2 additional years for compliance, but states that primacy agencies may do so on a utility-specific case-by-case basis. And so if that happens in Wisconsin, some water utilities may have until the end of 2028 to achieve compliance. And so what does this all mean for Wisconsin, which is essentially what we are covering here today? And so first, I'm going to talk about how this affects the state drinking water standards under NR 809. And so, but before I do that, I want to just provide some of the context, lay of the land, status quo of the law related to the regulation of PFAS in public water systems in the state of Wisconsin. So as you know, Wisconsin has a standard at 70 parts per trillion for PFOA and PFOS. This standard was set on EPA's 2016 health advisory levels. I think you're pretty familiar about the history of this particular rulemaking, in where DHS recommended a 20 parts per trillion based on some toxicological assessments that were not considered by the EPA's 2016 health advisory levels. Then the Natural Resources Board weakened the standard arbitrarily in February of 2022. The final draft went through the entire rulemaking process, became law and effective in August of 2022. And then the DNR, that has us, the DNR is currently collecting data statewide. So that is essentially the status quo of the law here in Wisconsin. And so now we need to talk about how this rulemaking would affect that status quo in the state. So first, just to talk about primacy requirements. As you know, the Safe Drinking Water Act provides that the Department of Natural Resources will be required to submit a revised program to EPA for approval. That needs to happen within 2 years, unless they request an extension. And so that will mean if they do that and receive approval by the EPA, that means that Wisconsin will have up to 4 years to revise its program. And so how can DNR receive an extension? Is it likely, is it not likely for that to happen in Wisconsin? So just as a preliminary matter, the Safe Drinking Water Act sort of sets a test for when extensions should be approved by the EPA. And essentially they happen only when the agency, in this case, the DNR, shows that they cannot meet the original deadline. So that will be the 2-year deadline for reasons beyond its control. And so can that happen in Wisconsin? It may. So we know that the DNR will have to go through rulemaking to make these revisions. And my understanding is that DNR intends to do so with speed and have a good effort to comply with that 2-year deadline. But the state rulemaking process has some barriers that may provide reasonable grounds for an extension here. That is, one is the REINS Act. As you may know, the REINS Act is the law codified in the Wisconsin Administrative Procedure Act that dictates that when a rulemaking has a compliance and enforcement cost of $10 million or more, the agency DNR loses its authority to continue that rulemaking process unless the legislature approves them to do so, or they modify the rule in a way to bring those compliance costs down. In this case, modifying the rule, the standard would not, to bring those costs down below that threshold would not be possible. And so the only option here will be for the legislature to approve that rulemaking and allow DNR to continue to go through the rulemaking process so that it can effectively and ultimately revise the state code. So that is one of the mechanisms that may play, or one of the laws that may play a factor for this extension. The other one is the legislative suspension. So under the Wisconsin Administrative Procedure Act, the legislature also has the authority to suspend proposed rules or even final rules. And so the question is whether they will maybe use that authority to suspend that rulemaking effort. So essentially in here we have the REINS Act, the legislative suspension authorities at the front end or the back end of the rulemaking process in Wisconsin that may or may not play a factor on when the state is actually to meet primacy requirements for this rulemaking. So then we have monitoring requirements. So there's a lot of information on monitoring requirements in the proposed rule. I decided to include just high-level notes here. So as a preliminary matter, compliance must for that initial monitoring will have to be done within 3 years when the final rule is promulgated. The standard is that there must be 4 samples per year, but the proposed rule contains a lot of burden reduction mechanisms and flexibilities to reduce the amount of sampling per year. And also another flexibility built into the proposed rule is that historical data may be used to satisfy requirements so long as the data adequately represents current water quality conditions. The EPA has put in the proposed rule a few guides to determine whether that historical data is representative or not. So they will be using that to make that determination to see if historical data can be used to comply with monitoring requirements. Some data that we have available in Wisconsin that may be used in this context is the data from the UCMR 5 and also the NR's voluntary and mandatory testing data. So we'll see to what extent that data can be used or not to satisfy that monitoring requirements. And now I want us to move to violations, MCL, exceedances, and then protective action requirements. So as you know, water systems that have PFAS levels in exceedance of the proposed MCLs will need to take action to provide drinking water, which meets that the levels set by the proposed rule. And so how exceedances and therefore violations will be determined. EPA plans to use running annual averages at the sample point. So essentially, they will be averaging sample analytical results during the previous 4 consecutive quarters. And so that's essentially how an exceedance will be determined. And also something to note is that the EPA also included in the proposed rule the best available technologies here for protective action, which include, as we are already familiar with, granulated activated carbon, anion exchange, and high pressure membranes. So that's essentially how the rulemaking will affect the state drinking water standards. Now I want us to move about groundwater standards, and why this is important part of the conversation is because, as I mentioned and alluded to before, the EPA rulemaking does not seek to protect directly people that rely on private wells for drinking water. So groundwater standards that are a state-based issue may play an important role in that. So here we have Chapter 160, which intends to minimize the concentration of polluting substances in groundwater through the use of numerical standards in all environmental regulatory programs. So this chapter sets an administrative process to produce these standards, which would be comprised of enforcement standards and also preventive action limits. So very briefly, I want to cover that administrative process set out by Chapter 160. And so first, we have the identification phase, where DNR, other agencies, or even the public may petition for this identification. If DNR determines that certain substances are or may be contaminating groundwater, then DNR will request DHS for review of the substances that have a health concern. Then DHS is charged with developing standard recommendations according to a statutory prescription laid out also in the statute. And then the fourth part of that process is the DNR has to engage in rulemaking to make that DHS recommendations, build them into the state code so that they are effective as numerical groundwater standards. So that's essentially the 4-prong process that's is set out in Chapter 160. So how does this really has to do with EPA rulemaking? Well, that's what I'm going to attempt to show now. And I'm going to use the example of rulemaking DG 17/2022 that includes PFOS, PFOA, PFBS, and GenX. So all substances also within the scope of EPA's rulemaking. Just to note that these substances were part of the cycle 10 and 11 failed state processes. And we have right now, those substances have existing DHS recommendations that are generally regarded or can be regarded as outdated. just for you to have a frame of reference on how outdated they may be. I included that table. So in the case of PFBS, the new EPA value is 2000 PPT, and the EHA's recommendation is 450,000 PPT. So there's quite a bit of a degree of separation here among the DHS recommendations and some of the values contemplated in that EPA rulemaking. And so here's where it gets really interesting. So in the scope statement, DNR provided that the department may request that DHS revise its recommended enforcement standards pursuant to Wisconsin Statutes 160.076 in light of new and changed federal number for certain PFAS. So that is included in the scope statement. Just briefly noting that also the public has the right pursuant to 160.076 to ask DNR to make this request. And so if that request were to happen, we will put us back in a position where DHS has to make new recommendations. It will have to revise its existing recommendations. And so how will the statutory prescription of 160.074 play out here? So we have a pretty good idea because the statute is really explicit about what needs to happen. So in the case where there's a federal single federal number, then the statute provides that that shall be the recommended standard. In the case of where two or more federal numbers exist, then the most recent one shall be the recommended standard. And the provision also contains sort of like a catch-all provision where DHS has the discretion to, is not required to do, but they may choose to deviate from federal numbers only if the federal numbers are missing significant technical information. Here, given how updated and how recent these numbers are, is very unlikely that this provision is applicable to that rulemaking. And so that begs the question of what is really a federal number? Well, the statute also defines that what constitutes a federal number in 160.013. And I don't want to spend too much time going through the definition. Maybe you can go and check in the statute, but I just wanted to make the point that the standard development process of the Safe Drinking Water Act contains federal numbers. And then therefore, following the statutory prescription of 160.07, that shall be the basis of DHS recommendations if a request for revision is done pursuant to 160.076. So that's why the EPA's rulemaking is of great significance also for the development of groundwater standards in Wisconsin. Here, just because I didn't want PFNA and PFHXS to get lost in the weeds, I just wanted to point out that they were part of the Cycle 11 failed rulemaking process. DNR, unfortunately, does not have time to finish that rulemaking process before the expiration of the scope statement. And so that's why I already called it a failed rulemaking process. And so I just wanted to pose the question of whether there should be a new rulemaking based on new recommendations. The difference between DHS recommendation and EPA values is contained in that table. And so I just wanted to put that, pose that as a question. And so that's essentially how the EPA rulemaking will affect state regulatory matters here in Wisconsin. But now I want to introduce another very important part of the conversation that Peter will help us through and will help us navigate, which is, since we are, it seems that we're going to be getting regulatory regulations to try to mitigate the health risks of these substances, how important it is to start talking about PFAS funding. And so Peter, here, I will pass it on to you so you can get us through that important conversation.
Thanks, Jorge. Can you click on to the next? Perfect. First of all, thank you to you and Peg and all of MEA for having me. Really excited to be here and really appreciate your leadership on all these really technical details around the process. It's really, really helpful. So yes, talking about the budget, I first kind of wanted to zoom out and reemphasize that all of this is first and foremost about public health, right? We know that these proposed maximum contaminant levels at the EPA mean that Wisconsin could soon have new standards that are much more protective against complications with pregnancy, protective against childhood development issues, protective against thyroid disease, testicular cancer. And so we have a really exciting opportunity to make sure that these proposed maximum contaminant levels get across the finish line. But we also know that there's going to be a need to support communities as there are new responsibilities, as they face new responsibilities. So thanks to the standards that we passed last year, we are starting to get a picture of where across the state we're facing PFAS contamination. So while the state-based standards are very weak, they have been helpful in helping us understand that over 70 Wisconsin communities have detected PFAS contamination. And those 70 plus communities account for over 2.2 million Wisconsinites. So we have a lot of work ahead of us. And the good news is that the PFAS specific budget recommendations provide a really, really good starting point for this work. So Jorge, can you head to the next slide? So a quick overview on what's included in Governor Evers' budget proposal. So first of all, $100 million for community grants. We know that there's communities, as they're detecting PFAS and as they prepare for these new maximum contaminant levels, they're going to need more funding to address this issue, to remediate. So what we really appreciate about the governor's proposal is that it creates a flexible program. It would create a flexible program. So regardless if you're a community with folks who rely on private wells or you're a community with folks who are on a municipal drinking water system, this $100 million proposal could benefit your community. Another piece that's really important is the $4 million for testing, monitoring, and standards. So while Wisconsin passed these weak standards for our drinking water for PFOS and PFOA, we obviously need to be testing for more PFAS chemicals. We also need to be testing in our soil and sediment, in our wildlife, fish, groundwater, surface water, ultimately air too, right? Like all of these pieces are part of the puzzle. They help us understand how to efficiently and effectively distribute funding. So we really need this piece of the puzzle to make it through the budget. And then the other two pieces of this are $1 million to collect, dispose, and replace PFAS-containing firefighting foam. We've heard that there is funding available for communities to get rid of their PFAS-containing firefighting foam, but not necessarily to purchase PFAS-free firefighting foam. So this would support communities on that front. And finally, $1 million proposal for emergency response and education. So, when communities detect, if they need emergency bottled water, need more information on kind of how folks in the community can protect themselves, what information should be provided, there's education through Department of Health Services. So all of these pieces work together, and we at Wisconsin Conservation Voters and across the environmental community in the state are really fighting hard for this $106 million proposal. Next slide, please, Jorge. So what we're hearing from the Joint Finance Committee, these are the 16 members of Wisconsin's Joint Finance Committee, 4 Democrats, 12 Republicans. They are incredibly, incredibly important for determining whether or not we move this great $106 million proposal forward. So this is where the budget, the proposal is at the moment. It is in the hands of these 16 folks. They will make the decision, and you and we across the state will determine whether they feel the pressure to make the right decision. So a little bit about what we're hearing. There's some good news and some bad news. We at Wisconsin Conservation Voters, we've talked to 14 of 16 of these members, all with a little some different nuanced responses on how they're thinking about PFAS. But across the board, the common thread is that folks seem to recognize that PFAS contamination is an issue across the state. They know it's something we need to address. but they are hearing about it as a Northeast Wisconsin problem and not necessarily hearing about it in district. And obviously, the issue is particularly bad in communities like Marinette and Peshtigo, right? Worst contamination, some of the worst contamination in the United States. And we know that it is not an issue that is just specific to Northeast Wisconsin, that there are 70 plus communities, 2.2 million plus Wisconsinites impacted in some way. So our task is to really make sure that these members, most of whom do have PFAS detections in their district, are hearing about the issue from constituents. Next slide, please, Jorge. So a little bit about kind of where we are in the process. So the Joint Finance Committee has been traveling around the state for their big public hearings, but also legislators have been holding their own hearings to hear about what folks' priorities are for the state budget. In May, the Joint Finance Committee is going to start voting on different proposals across the board on lots of different issues that we all care about. June, what they have proposed is going to go to the full legislature, the Assembly and the Senate, and then towards the end of June, the governor is going to decide what to do with that proposal, sign it, veto it, sign with some partial vetoes. We won't know what's going to happen until it happens. And then in July, the fight for legislation begins. So one thing I wanted to emphasize here is that we are going to continue to fight for this $106 million proposal. One of the, till the end, one of the things that we're hearing is an appetite for funding, but not necessarily an appetite for determining how that funding should go out the door. So we could see a situation where the Joint Finance Committee and the legislature says, all right, we want to allocate X amount of dollars for PFAS remediation, but it's going to take legislation after the budget passes to determine how that funding goes out the door. So even in that case, the fight for this funding is essential because it allows us to do all this work after budget season. But just wanted to be transparent that, even if we get some good resources through this budget, there will, there's a good chance that there will be a fight afterwards to determine how that funding can be distributed to our communities. Next slide, please, Jorge. So how to help? As I mentioned, we really, really, really need legislators to be hearing about this issue. We need it. We had one Joint Finance Committee member say to us that unless he gets 5 calls a week about an issue, it is not elevated in their office as a priority. So these calls can be really simple. Hey, we support the governor's $106 million proposal for PFAS and would like you to support it as well. This is really just a matter of making sure they're hearing that Wisconsinites across the state want to see action on PFAS. We have a short toolkit that I'll throw into the chat if it's helpful. It provides a sample script. It also provides a sample script for if you decide to attend a public hearing or submit a letter to the editor. These are other ways to not only get the message in front of legislators, but to help elevate with other concerned community members, because it's powerful if you can call your legislator, if you can write a letter to the editor, if you can show up at a public hearing, and it's even more powerful if you can get 2 to 3 friends or family members to do the same. And then finally, I will also throw our registration for Conservation Lobby Day into the chat, but really, really encourage you to attend our Conservation Lobby Day. This is a day, so Tuesday, April 25th, that we convene with environmental partners across the state. So we're really excited to have Midwest environmental advocates there as one of the 40 plus groups endorsing our agenda for the day and doing a presentation in the afternoon. But our top priority for Conservation Lobby Day is support for this $106 million proposal. And we need you not only because it's important for you to making these connections directly with legislators and that they're hearing about it, but we also collect what you hear from your legislators. So everybody will go into their meetings with legislators with a form of, how did this legislator respond to the ask for $106 million for PFAS? And then based on what you hear, we have this reporting form that comes back to us, and that's how we determine our strategy for May and July. So there's only so much that legislators will tell me as a lobbyist. We really need constituents helping to gather information and shape our approach to making sure that we move these good pieces across the finish line. So just want to reiterate that these budget proposals are really a bridge to being able to efficiently and effectively implement the maximum contaminant level, the new maximum contaminant levels, and protect Wisconsinites' public health. So I know many of you on this call are already really well engaged with this process, and I wanted to say thank you for all of your work. If you're not and you would like to be, here are some really great ways to help. And again, I will throw a couple pieces here into the chat, but I think that's it for my bit. So I'll turn it back to Jorge.
Thank you, Peter, for really helpful information to see how PFAS funding is also a really important state matter here in Wisconsin as we navigate protective regulations for PFAS. So yeah, before turning into the Q&A portion of this webinar, I just want to provide some information about how to participate in the rulemaking process, in the EPA's rulemaking process. So you can either provide written comments or participate at a public hearing and provide oral comments. If you intend to draft a comment letter or just provide written support for this regulation, you can do so by identifying the docket ID number that is in the PowerPoint presentation, and you can do that by going to regulations.gov. You have until May 30 of this year of 2023 to do so. If you want to participate in that public hearing, you have to register in the link that I provided there. You need to do that by April 28th of 2023. The public hearing will be held on May 4th of 2023. And so that's some ways you can show support for this protective action by the EPA. MEA intends to draft a comment letter in support of this regulation and just show that impacted communities throughout Wisconsin really need to be protected by the EPA. So that's it. If now we can just turn into questions if you have any. I only see one in the Q&A portion here of Zoom. So let me see if I can go ahead and address that. So the question is formulated for me to give an update of the groundwater standards in Wisconsin. And so with respect to those 4 substances, PFOS, PFOA, GenX, and PFBS, that are part of that DG 17/2022 rulemaking, we understand that the DNR is shortly going to determine whether or not to ask DHS to revise the recommendations in light of new information from the federal government. So that's the status on that. So hopefully we'll hear by the end of this month whether they are going to go through the rulemaking with the existing recommendations or whether DHS will be charged of revising those recommendations. Laura also put in the chat whether I can share my slides. I will definitely be sharing the slides. We'll also be distributing the recording of the webinar so that it can be distributed to your members and just with the public at large. Or you can use it as a resource for sure. So Susan Davidson asks a little bit more about groundwaters, and so I know that this is a really important matter in Wisconsin. About 1/3 of Wisconsinites rely on private wells for groundwater, and they are not subject directly to the EPA's regulations. So I just want to emphasize that it is really a really important matter in the state, so we can protect all of Wisconsinites. They deserve the same protections. So again, groundwater standards, the 4 substances that have a chance to go through the rulemaking process are PFOS, PFOA, PFBS, and Gen X. All of the other substances that are part of cycle 11, that rulemaking is a failed process. Their DNR has indicated that they don't have enough time to work on it because the scope statement will soon expire, and there's so many steps of the rulemaking process that they have not gone through yet. So the fact of the matter is that DNR is seeking to regulate at this point in time only for substances. Oh, and so Susan Davidson also asked about what groundwaters are included, and my understanding to that, so that the standards developed under Chapter 160 can be used in different environmental programs. One of them is the spills law, for instance, where all of those regulatory programs use these standards by reference, and they ultimately seek to minimize the concentrations in groundwaters of Wisconsin for protection of public health and the environment in general. I'm gonna allow for probably a few more seconds, so a minute or so, to see if anyone else puts a question in the Q&A. Again, this recording will be shared so that you can use it as a resource, or you can share it with your members, and also the slides. All righty, I don't think there's any other questions. If you come up with any particular questions after this webinar, always feel free to reach out to me, to Peter, so that we can be responsive and just share the information and analysis as we know. So other than that, Peg, I think we're done with the presentation. Alrighty, folks, I just wanna again say thank you for your time today here. Again, you have questions, feel free to send it my way or Peter. And other than that, have a good weekend.